Okay, good morning. Today is the 19th of October, 2019. It's a little bit frosty today. It's 31 degrees. I had to scrape my windows. So today, this is part two of the County Notary. I'm going to be reading from my notes. And so here we go. Okay, so the County Notary, the title is County Notary. Doesn't matter if you're nominated and elected by the state Jural Assembly or county, um, and therein by the grand jury. So the basic county notary is elected by by grand jury. Um, and the people on the grand jury, this would be 12 men who are over the age of 21. And I want to point out that the decisions are then once the county notary is elected, then that has to be properly recorded. And that can be done. We have our own land recording office. We don't like using the de facto offices to do that. And I also wanted to mention men over the age of 21 because, at least the beginning, because remember, you're working with old law, common law, even in equity from 1776. So it was the de facto that elected to allow an 18-year-old to vote. It was the de facto that elected to allow women to vote. It was not the people at common law. So those things actually need to be dealt with, from my perspective, in Congress and brought forward properly. Um, so at any rate, what are the qualifications for the county notary? Well, I think of the county notary as being one who is, number one, on the land, working on the land from the land jurisdiction. So this cannot be a U.S. citizen. This cannot be an attorney or anything like that. This one has to be one who is, for my part, like a surgeon, a doctor, surgeon, general, or someone who is well qualified, um, someone who understands what is going on, or is able to quickly learn what is going on. In the past, the latter 1790s, early 1800s, there were farmers elected to the Supreme Court. Now, that does not mean that they weren't intelligent. In fact, they were probably very intelligent and very well versed in law, or at least in understanding the variations of law. So, we're going to talk about the qualifications here. But first, I wanted to point out what law actually is. So, law, the word law, LAW, came out of the Vatican. And there are three jurisdictions on the planet, only three. So, LAW stands for land, air, and water. So there are three jurisdictions. What's a jurisdiction? Juris means law, diction means words. So that means each of these three jurisdictions have their own language, and you cannot mix these languages. You don't mix ecclesiastical with commercial. You don't mix the common language of the people with commercial. You don't mix the common language of the people with ecclesiastical. These are three separate jurisdictions, and the notary must understand all of these languages because everything that a man does depends on the words that he uses. This is extremely important. If you watched the first video, then you know more about what I am talking about. And so you cannot go around using the word document unless you want to be commercial. You use the word paperwork. On the land jurisdiction of common law, we don't sign anything. We don't use any sign language. We autograph. All right, so the notary needs to understand these languages. So, number one, some of the actions that the notary will be doing, some of the responsibilities and duties. The notary should be clear, clear mentally and emotionally about the language of the office of notary, like I was just saying. That's number one. They must understand that there are three different languages. Of course, you know the commercial language is called legalese. Number two on my list here, writing of verdicts as given by the jury foreman. So what does this mean? A grand jury is pulled together by an administrator. That could be your secretary of the Jural Assembly. So let's say the secretary works as the administrator and brings together the grand jury. And then that grand jury elects a foreman. So they nominate a foreman, and then each of the jurors will be given a number. So you have juror number one, juror number two, juror number three, etc. And they're never called by name. The only one out of that entire jury that will autograph the paperwork will be the foreman. And then the foreman will take that paperwork that has been written up to the notary. Now, the notary can actually write the verdict and autograph the verdict as given by the foreman, or the foreman can write that up and hand it to the notary, and together they will formulate exactly what was supposed to be said, so that it's the notary's job to make sure this is done properly. It's the notary's job to make sure that this is lawful. So everything must be done lawfully. And that's what the notary must do before the notary authenticates it. Before the notary actually puts the autograph on that paperwork, it has to be done right. So if it's not correct, if there's something going on that's not correct or not lawful, it goes back to the jury. It will go back to the jury, and it will be corrected and then come back again. Okay, so it's extremely important that the notary understands all of the processes affiliated with the jury and writing up the paperwork. The language of that paperwork is extremely, extremely important. For example, on the land, we don't use capital letters. Capital letters are commercial. So if it's a verdict at common law, more often than not, you won't find or anything, maybe in the margins or the heading, you might find a capital letter, but in the basic format structures, you're not going to find that. There's a lot that a county notary must understand about the common language of the people and the differences between the jurisdictions. Okay, number three. understands the office, and moves the system of justice as required by word or paperwork. So that notary has to understand the language, has to be able to speak the language, and has to be able to write that language. So they have to know what word or paperwork is required at all times for all actions, including who to move the action, when, where, why, and how. So, do they need to move the sheriff to enforcement? Do they need to move the grand jury to correct something? What do they have to move? Where do they have to go? They have to understand all of this. They need to know basically how to do research, need to know how to find answers. They need to know how to contemplate the decisions that they have to make. And you'll hear more about that as we go down through the list. Okay, number 4. The notary understands the use of the recorder's office. So the recorder's office is extremely important because it's the secretary that can verify what the notary does, and it is the notary that verifies what the secretary does. So the witness to a verdict, for example, by the grand jury, will no doubt be the administrator or the secretary, okay, and the foreman. So if there's a witness that's needed, they witness for one another. Number 5, interacting with all the people on every level of thought, education, creed, degree, level, color, sex, class, age, so on and so forth. Okay, so the notary must understand, cannot be biased, and needs to understand that there are every age, every sexual orientation, every color of skin, every class of people, rich, poor, everybody, and they're all equal. So there can be no bias within that notary office. Also, the notary understands uh, authentications, verification, testaments, living testaments, which is common law language, versus commercial terms and commercial terminology, which would be documents, certifications, and things of that sort. So, on the land jurisdiction at common law, we don't have certifications and we don't have documents. We have verifications and we have paperwork. We have no affidavits on the land. We have living testimonies in the form of an affidavit. That's totally different because you're a living man or woman making a testimony in the form of an affidavit. And I talked about these things on the last video. Number 6, knows how to manage the judicial office from the inside out. This is extremely important. So the next few are all basically lumped together. You have knows how to manage the court, knows how to speak to the sheriffs and marshals, and use enforcement. So number 6, knows how to manage the judicial office from the inside to the outside. So this notary has to understand how the office works and how to manage it. So you're going to have clerks, you're going to have sheriffs, you're going to have marshals, you're going to have councils. So all of these people are going to need some kind of leadership. So your notary is going to have to be that leadership within this office, the notary office, the county notary office. And they're going to have to be able to work with all of these people and they work from the inside to the outside. So the people will be coming in and out. They know how to manage the courtroom. Same thought, same process. They know how to manage the courtroom. They know what to do with the sheriffs, with the marshals, with the councils, with the people who move in and out. They know how to work the enforcement. So they know what paperwork is needed, they know who to contact, and they know how to get it done. All right, moving down to number 10. Understands jury nullification. I'm not going into a whole lot of jury nullification, but basically you have, maybe let's say there's a commercial uh, legalities, rules, regulations, ordinance, code that is not up to par with the land jurisdiction. Let's say you have the right to travel freely, and that right has been hindered, and so the jury has the right to nullify any ordinance that was created. Let's say the let's say the borough creates an ordinance that you're not allowed to flash your headlights 3 times at anybody within the borough. And that's what they fine you for. Well, the jury's allowed to nullify that. They can just simply say, that's just stupid. They nullify it. It goes away. Okay? Because even though these folks make up rules and regulations, that doesn't mean that they have to stand. So statute, rules, regulations, ordinance, and codes are all commercial. So a land-based jury can simply nullify those things because they're not lawful. They are legalities, and a legality is not lawful. So you have corporations, which all governments are corporations. So you have a corporation, a municipality, or a borough creating a rule or regulation, or the state creating a statute, and the jury nullifies it. It's in a different jurisdiction. Only a U.S. citizen would have to follow that. All right. 11, 12, 13, they basically all go together. So the county notary must understand mediation, arbitration, and basic administrative actions. So it is our hope that when the courts are all set up properly, that there will not be hardly any litigation, that mostly everything should be gone to mediation. And then if need be, it would go to arbitration. And I don't have time to talk about those terms. But mediation is basically where both sides get together with a mediator and they talk out the problem and they deal with it. And then if that does not quite work for them, they can go to arbitration. And the difference is that arbitration, you have somebody who is an arbiter who will make the decision for them. So at arbitration, this is what they do in courts today. Most courts are worked through arbitration, where you go in and the judge decides what's going to happen between the two sides. That's arbitration. So you don't really want to go to arbitration. That's a last step measure. You want to go through mediation. But the difference is, if you go through mediation and you come up with a decision between the two parties, then that whatever paperwork that you come up with, it's autographed, it goes to the notary for enforcement. So the notary then can look at it, autograph it, they record it, and it becomes law. It becomes an actual contract. So all laws in that case would be contractual because it's something that both parties have agreed to. And therein that's something that people need to understand. Most everything that somebody does during the day, man, woman, doesn't matter, is commercial. You are always working commercially. You don't get a bank account unless you are working commercially. For example, for the most part, maybe a church might be able to do that or something else, but for the most part. So from the time you were born until the time that you die, you work commercially. So you have to understand you cannot live on the land or live at sea or live at the air jurisdiction only. You will always be touching all three jurisdictions at the same time. Always. But it's the words that you use and the language that actually differentiates which one you are standing in. So even though people want to claim, oh, I'm on the land, well, you might be on the land, but you're still always going to be working some kind of commercial endeavor or ecclesiastical endeavor. You cannot separate yourself from these jurisdictions. You just need to understand them and the languages that make them move. It's the language that makes them move, and it's the language that separates them. Okay, so let's see. Number 14. The county notary understands, okay, so this is very important, that they understand the law, which is, for example, treaty law, common law or natural law, equity, trust law, the unknown law, maxims of law, etc., etc. So there are different kinds of law, and the notary must understand all of these laws. They might not be able to repeat a law or a statute, for example, but they understand the relationship between them. So, treaty law is your international law. Common law or natural law are both the same. So, whatever is common to the people is actually what is natural. So, you could call it common law or natural law, and they're both the same thing. And then you have equity, which is when the common law does not work, then equity steps in, being that whatever is equitable, equal to both sides, then that should be what comes out of, for example, the mediation or arbitration or whatever is going on. Then you have trust law. Now, trust, you have commercial trusts, or you have common law trusts, or you might have ecclesiastical trusts. So there are different kinds of trusts that people work within. And so the notary needs to understand all of these things. Just giving you examples. If you're going to elect a notary for a county or for a state, that notary needs to know what's going on. Number 15 says they understand. Okay, well, here we go again, the same thing. They understand the Declaration of Independence, the Articles of Confederation, the meanings, the influences of all the contracts and commercial law, like the constitutions, on all levels, meaning that all three jurisdictions. So, as I said in the last video, a constitution is a contract. So that notary needs to understand all commercial law. all the rules and regulations that go along with commercial, as well as what is common or ecclesiastical. They just have to understand everything. And that takes in those basic organic laws as well, the Declaration of Independence, the Northwest Ordinance, and so on and so forth. 16 says ecclesiastical law. 17 understands the word law, the land, the air, the waters. I've already explained the three jurisdictions, and that the language, there's a language for all three jurisdictions. So they understand. Last I have on there, number 18, they understand the rules of banking. So this is extremely important. I need to make a whole video on this because the notary must understand the rules of banking. All of the courts are basically operated as a bank. So if you just think about it for a moment, I'm sure I mentioned this before, but you are charged, they make charges against you. Well, that's a financial charge in a courtroom. In these administrative, commercial, corporate courts, they will try to charge you with something. Well, that means that they're bonding you, and they're trying to charge you for something um, financially. That's what the word charge means. Even when they say it's a criminal charge, uh, I'm not going to go into this, but that's what the notary needs to understand, that these are rules of banking that's being used commercially in a courtroom whenever they're working through these different things. And even in equity, they need to understand this. Um, and then, the notary needs to have integrity. Morally, they need to be compassionate. They have faith, grit, humor, self-determined, logical, have common sense. I like years ago, there was a man who taught me to be as a velvet covered brick. This is so cool, a velvet covered brick. So I think of a notary as being the same, a velvet covered brick. It's not a rock, it's a brick. It's actually formed. It has a form that has been created. In other words, there's an education involved. There's grit. There's experience. It's actually firm, but it's covered with velvet so that when you touch it, it feels nice, but it's firm inside and it's constructed. So think of a notary in that sense where they are like a velvet covered brick. They know what they need to do and they are firm about what they need to do and they get it done. So, this notary has more authority on the land than the Supreme Court. Now, the Supreme Court is supposed to be the only Article 1 land jurisdiction court. The Article 3 jurisdiction court is supposed to be the federal Supreme Court. Whether or not they actually do what they're supposed to do, that's another question. But we're talking about county notaries. And because the county notary works on the land jurisdiction, there are no other judges that work the land jurisdiction. They are all commercial. They were made commercial back in like 1933 under FDR whenever he tried to take over the whole country. And they did. They took over everything for about 80 years. So, okay. Again, everything depends on the language. And I'm thinking I'd like to talk about bonding. I'm not going to talk about bonding now. I want to wait for banking. So I would like to go through this. The county notary does need to understand banking. County notary does need to understand bonding. The people need to understand banking, and the people need to understand bonding. And so the people need to understand the rules that we live by right now. They are all commercial. They are not common law. They are commercial. And so we need to be able to move the courts out of that commercial capacity onto the land. And the only way you can do that is with your county notary. That's the only way you can do that with the grand juries, the common law juries, and the notaries. You want your own federal marshals. And again, maybe I should explain this, the word federal. Okay, so let's do this again. Federal. You have the Declaration of Independence that created basically a family unit, which is your first government, is the family. And then you have a leader of a family, and you have a group that get together, which is called an assembly. And that would be a state assembly, for example, your state jural assembly, or that could be a grand jury, or any kind of jury, or that could be you could work at a municipal level or township level or uh, county level. Those are all assemblies whenever the people get together. So you have your county assembly, which would include your scribe, your sheriff, your commissioners, your notaries or justice of the peace. So you have all of those things that come together um, at the state level. And so let's go back. We have level number one is the family. Level number two is your assembly. And then you have your assembly, which could be county or state. And then you have elected delegates. So the assembly elects delegates to work internationally outside the state. And that is the federal jurisdiction. So every state has a federal jurisdiction. And then when that federal jurisdiction, those delegates go to Congress and the senators get together, then that is the confederation. So you have a federation, which is the state or federal. All I know that people have always thought that the federal means something other than, but it's the international jurisdiction of the state, which is federal. And then when they get together as a unit, that's a confederation, which is why it's the Articles of Confederation and Perpetual Union. That's what was created, the Articles of Confederation, which is when the federal states all get together as one union. So that's where the word federal comes from. So you have three governments presently under three separate constitutions. The municipal government is bankrupt. It was already bankrupted. The territorial is still in business under Chapter 11. And then you have the federal government. So you have federal, territorial, and municipal. Those are the three branches of government. It's not judicial, executive, and legislative. Those are not branches of government. That's a democracy. Democracy sucks. You don't want to be in a democracy. You want to have our Republican form of government. The difference is a Republican form of government, you have a jury, and if depending upon how it works, you could have 12 people on a jury. If 8 out of the 12 were to find in your favor, then that's a Republican form of government. That's what a Republican form of government is. So a democracy, it's 50-50. If 49% don't like it and 51% do like it, well, then it will pass. And 49% of the people don't even like it. So democracy has, for centuries, for eons, it has never worked. It is not a form of government. It is a form of mediation or arbitration. It is not a form of government. So we have a Republican form of government, and it does work. And so I'm explaining again federal, the word federal. So you have federal circuit courts within every state. That is your highest court, aside from a superior or Supreme Court. But the Supreme Court does not make decisions, they only have opinions. So, for example, if there's an appeal out of the federal circuit court that would go to a Supreme Court, the Supreme Court would look at the decision, and the only thing the Supreme Court does is says, yes, it was lawful, or no, it was not lawful. That's it. That's their decision. That's the same thing that the Supreme Court of the United States of America does. That's the only thing that they can do. They only create these opinions. They do not make judicial decisions. That's up to the grand jury, or that's up to the jury. That's up to the people. So that's why you have a federal circuit court. That's why you have this international federal jurisdictional place. So you have the family, which is the basic unit on the land jurisdiction. You have the commercial jurisdiction, which is the assembly when they get together. And then you have the uh, jurisdiction, which is federal, which is international. And that too is commercial. But this is where I said earlier you have people on the land crying out to the sea or talking to the sea. And as a man on the land, for example, you tell the people what you want them to do. You tell it's the people who tell government what to do. Government does not tell people what to do. So the land tells the sea what to do because the land created everything commercial. So the people on the land created the sea and everything commercial. So the sea does not tell people what to do. Government does not tell people what to do. The people rule the government. So the people tell government what to do. So at that federal level, you elect delegates to go to Congress, and those delegates do what the people tell them to do. So Congress creates something. Let's say they create legislation that creates, you know, the judicial system that we want to have. Then that comes back to the states, and they would all have to agree to it. And then it would become law when 3/4 of them agree to it. So um, this is the way that the government's supposed to work, a Republican form of government. It's not the way it has been working. So I hope that you understand more about the notary, the responsibilities of the notary, and in particularly the three languages that the notary must understand. The air is ecclesiastical, the water is commercial, and the land is your basic natural or common law. And none of these touch one another. They are all separate from one another. They are all three separate languages. So, all right. Until we meet again, I think I will be working part 3 as soon as I can, and I will probably be on banking and maybe on the individual processes that people go through in order to free themselves from the de facto. So, thank you.